Good morning, everybody. Hopefully you can hear us. Welcome to session 4 of our construction law training, where we're covering other key clauses in JCT and common amendments to the JCT forms, a very catchy title. We haven't got Andrew with us today, so in his place we have the lovely Carolyn.
Good morning, everybody. For those of you that don't know me, I am a partner in Archor. I specialise generally in disputes, albeit I do a lot of dispute avoidance work during the course of projects, and I also do a lot of pre-con advice, which tends to be reviewing significant contract amendments for contractors. So I've got a lot of experience in what we're going to talk about today. And I apologise in advance. I'm undoubtedly a far less exciting presenter than Andrew. He actually has a certain flair for this, albeit we don't tell him that to his face. But hopefully you will find this session useful nevertheless.
You all know who I am by now. I'm Hannah. I'm a partner here at Archer as well, specialising mostly in adjudications and now construction law trainer as well.
So these are the other partners on the screen now. I'm sure a lot of you will already be familiar with them. I'll just run through. There's obviously Andrew, Ruth, myself, Hannah, Ollie and Rory. And we're based across our 2 offices in Colchester and Cambridge. If anybody that doesn't know, the name Archer actually comes from all of our first initials. So there's a little anecdote for you there. And this slide just shows our wider team. So we've got a wealth of individuals now working for us in all various aspects of construction. In addition, since this slide was prepared, we've also got a new starter in Cambridge. Her name's Lily Calver. She has joined us as a paralegal.
So, as I started off with, this is session 4 of our construction law training. So today we're going to be covering other key clauses in JCT contracts that we haven't discussed in earlier sessions, as well as the common amendments that you find to those clauses. So specifically in this session, Carolyn and I are going to cover changes, partial possession, liquidated damages, defects, suspension and termination, and also the common amendments you'll find to these clauses, and a couple of other amended clauses at the end too. So throughout this session, we're just going to refer to clauses in the JCT design and build form of contract.
So I will start us off. Firstly, I'm going to look at changes or variations. Just to point out, firstly, interestingly, these terms are used interchangeably within the JCT suite. So in the D&B forms of contract, it's referred to as changes, but in the standard suite, they are referred to as variations. However, it's generally understood that either term means the same thing. So the first thing to consider when looking at changes is what actually constitutes a change under your relevant contract. So under the JCT suite, this is governed by clause 5, and there are 2 main categories of change. The first category of change is where there has been a change to the ERs, which requires a change to the works. And this is shown in clause 5.1.1 on this slide. So this category includes additions or omissions or substitutions of the work that was otherwise required within the ERs, changes to the materials that were otherwise stipulated in the ERs, and changes in the ERs which make it necessary for site materials to then be removed from site. It's important to note that such changes to the ERs should always be a change, irrespective of whether the contractor has taken full design risk. Because even if the contractor accepts the risk of the design in the ERs, and that includes the risk of any errors in the ERs or discrepancies between the ERs and CPs, ultimately, if the employer ever wants to change the ERs after the point at which the parties have entered into the contract, that should constitute a change. Moving on then to the second category of change, this relates to changes to the working arrangements, as shown in clause 5.1.2 on this slide. This scenario covers changes to access, the working space, the working hours, or the order of works to be carried out. Again, this refers back to the ERs. So something's only a change if it has changed from the arrangements originally agreed within the ERs. And the consequences of a change occurring, which I will move on to now, doesn't differ depending on whether the change derives under clause 5.1.1 or 5.1.2. So what happens if a change occurs? First and foremost, it's important to recognise that if a change is instructed, contractors must generally comply with that change. The unamended JCT wording allows contractors to raise reasonable objections to instructed changes, but in reality that is often amended so that objections either can't be raised at all or they can only be raised on health and safety grounds. The unamended JCT wording also requires any changes to design under a D&B contract to be subject to the contractor's consent. But again, that is often amended to give the employer full rein to make whatever changes that they see fit. So generally, contractors have to comply with all changes. A failure to comply with an instructed change can result in the employer then instructing another contractor to do those works and charging the original contractor any losses that it incurs as a result. So it's always worthwhile, if you're ever unsure, do take legal advice on the position, because simply refusing to carry out works can actually have serious consequences. So once you've established whether compliance is compulsory, it's then important to note that changes are both a relevant event and a relevant matter under all of the JCT suites. And this should never be amended, even if the contractor is taking full design risk under a D&B. Contractors do, however, need to make sure that they've properly notified of these relevant events and or relevant matters within any stipulated timeframes as set out in the contract. I think it's been covered in one of the previous sessions that these time frames are quite often amended to quite short periods, and that they become condition precedent to the various recoveries of an extension of time or loss and expense. Thereafter, if the change causes a delay to the completion of the works or a section, and the contractor has already properly notified of that potential event occurring, the contractor will be entitled to an extension of time and loss and expense. Changes may also have an impact on the contract sum, and so I'll now look at how changes are valued in that respect. So under the JCT suite, this is again dealt with under clause 5. The first consideration is whether an agreement can be reached. And if an agreement can be reached, then the agreed sum should be applied for by the contractor and then certified by the employer. However, in addition to this, we always recommend that any agreement on the value of a change is separately recorded in writing outside of that certification process, so that you've got evidence of the agreement. And this prevents either party trying to backtrack on that agreement later down the line, which is permissible if it's only been recorded in interim applications and interim certificates up to that point in time. If no agreement can be reached, then the valuation rules apply as set out in the contract. So what the JCT suite says in this regard is that for omissions, the price in the CSA is used. For additions, firstly, if there's any similar work in the CSA, then the CSA price for that work will be adopted unless there's been any changes in conditions to depart from that agreed price. If there's not any similar work in the CSA, then a fair valuation is made. So that's normally done by reference to market values and what is reasonable at a given time. In addition to this, there's also allowances given for any additional or reduced design work, any additional or reduced site administration or facilities requirements, and any temporary work. So moving on then to common amendments to the JCT change provisions. Clause 5.1 itself is actually rarely amended, but there are several other clauses within the contract which deal with changes, and they are often amended. Three that I want to quickly look at today are condition precedent clauses, clauses that deal with changes to statutory requirements after the base date, and bespoke clauses that deal with omissions. So firstly, considering condition precedent clauses. We've dealt with condition precedent clauses in previous sessions, but just to recap, a condition precedent makes recovery of a benefit contingent on that benefiting party first doing an act. Sometimes contract will be amended to make notifications of changes a condition precedent to the recovery of any resultant uplift to the contract sum. So it's always important to check if any additional notices are required over and above the usual delay notices. I've put on this slide now an example of such a clause. We always recommend that these types of clauses are deleted, but if you do ever have such a clause in a contract, it's imperative that you comply with it. Otherwise, even if there has been a clear change, and even if you've otherwise notified of delays and secured your right to an extension of time and loss and expense, you can still lose your right to claim the underlying uplift to the contract sum, so the value of the change itself. So moving on to changes to statutory requirements. Under the unamended JCT suite, changes to statutory requirements after the base date are an employer risk. However, this is often amended to seek to place this risk onto the contractor. And again, I've put an example of such amendment onto this slide for your reference. This clause as shown on the slide would effectively mean that if the law changed or if a planning condition changed after the base date, the contractor would have to comply with that change at no extra cost. This is always something that we recommend remains an employer risk, and it's standard in the market for this to remain an employer risk, even if the contractor has otherwise taken full design risk. So do keep a lookout for these types of clauses. Then the last common amendment to change provisions that I wanted to talk about relates to omissions. So the JCT suite of contracts enables an employer to omit works under the contract, and this is necessary for a variety of practical reasons. However, the JCT contracts do not allow employers to award those omitted works to a third party. So under common law, an employer can only omit works if those works are no longer needed. And this is often referred to as a true omission. And it is actually a breach of contract to omit works from the contractor and then award those works to a third party. And this is ultimately to prevent contractor shopping. If an employer did this, so if they omitted works and gave those omitted works to a third party, damages would be payable to the original contractor, and that would include loss of profit on the element of omitted works. But parties can contract out of this common law position. So I've given an example clause on this slide. If this clause was included in a contract by an employer could omit works and give those works to a third party without having to pay any loss of profit to the original contractor. So it's really important, therefore, that the employer is never given an express right to omit works and to give those omitted works to a third party. And as long as you don't have that express right in the contract, the common law position prevails and the employer cannot do that. So just to summarise then on changes, what you need to be thinking when you're reviewing contracts and when you're working under contracts, do you have any condition precedent clauses to comply with in relation to delays, loss and expense, and or the contract sum? If so, when do you need to give notice by? Who do you need to give it to? Consider what your contract says in relation to verbal instructions as well. There's often a requirement to confirm verbal instructions in writing within a certain period of time. And again, sometimes this can be a condition precedent to getting paid for any additionally instructed works. And as always, I know as lawyers, we like to bang on about this all the time, but put everything in writing, including any agreement that you might reach on the value of changes. In the event that you ever do end up in dispute, it is so important to have a paper trail as to precisely what has happened. Okay, so moving on then to partial possession. Partial possession is basically where prior to practical completion or sectional completion, the employer takes possession of part of the works or part of a section of the works. And the part that is taken is referred to under the JCT suite as the relevant part. The unamended JCT wording requires the contractor to consent prior to partial possession being taken, but no surprises, the JCT is regularly amended to allow an employer to take partial possession without the contractor's consent. And the result of this actually is that there can often be disputes over whether partial possession has actually been taken. Partial possession is often utilised by the employer for the commencement of fit-out works, and we regularly see it where works are in delay, and for whatever reason, the employer is then trying to minimise the overall delay. It's worth clarifying at this point that partial possession is different to early use under the JCT. So early use, and in my mind, it sounds a bit wrong with the names, but early use actually means that the contractor retains exclusive possession of the site, but the employer is allowed, again, usually with the consent of the contractor, to use part of the works before practical completion of the site. Partial possession is different to that because it signifies that the employer has taken possession away from the contractor, and the part that is taken is therefore deemed completed. So what happens if partial possession is taken? As I just noted, the relevant part, so that's the part of the works that the employer takes possession of, is deemed to be complete when possession is taken. This therefore triggers both the commencement of the defects liability period and the release of retention for that part. And in addition to this, any recoverable liquidated damages become prorated. And the LDs are prorated by the value of the relevant part, not by the physical square area of the relevant part. So as a result of this, employers are often keen to deny that partial possession has occurred, and therefore disputes can arise. If disputes do arise, they're dealt with subjectively on a case-by-case basis. There are also other practical considerations if partial possession occurs, such as insurances, because the relevant part, which is taken by the employer, becomes part of the existing structure for the purposes of insurance at the point at which possession is taken. So looking then at common amendments to the partial possession clauses, as noted above, it's common to see amendments to the JCT clauses that remove the requirement for the contractor to give consent. We also often see clauses which allow the employer to carry out certain works on site without it constituting partial possession. And depending on the nature of the works and the level of control taken, this can sometimes blur the line between what is and what is not partial possession. So I've included on this slide an example of that type of clause. We always advise clients to agree any access regime or usage plan prior to entering into the contract, and to actually append that to the contract so that the parties have agreed and made clear what can be done without it constituting partial possession. And if there's any change to that agreement, it may be that partial possession has occurred, or potentially it may be that there has been a change or an employer impediment under the contract, which triggers, as we've already said, a relevant event and or relevant matter, and potentially an increase to the contract sum. So the last point that I'm going to discuss before handing over to Hannah is liquidated damages. So starting at the basics, what are liquidated damages? Liquidated damages, or LDs or LADs as they are often referred to, are a pre-agreed level of compensation payable for delays. So if liquidated damages are included in a contract and the contractor fails to complete the works by the date for completion, the employer will be able to deduct liquidated damages from the contractor. The amount to be deducted is normally expressed as a weekly rate or pro rata for part of a week. And it's quite common to see the weekly rate differ depending on how far in delay the works are. So, for example, you might have expressed in the contract liquidated damages of £10,000 per week for weeks 1 to 4, then £25,000 per week for weeks 5 to 8, and then £100,000 per week thereafter. Liquidated damages can only be deducted where the works have not been completed by the completion date. And it's important to note at this point that if the contractor is entitled to an EOT and that EOT is granted, the completion date moves. So liquidated damages are only payable for any period. Sorry, liquidated damages aren't payable for a period where the extension of time is granted. They're only payable for a period thereafter, so past the date of completion. It's also important to note that if there are sections in the contract, then liquidated damages should be expressed at a rate that is payable for each section. And when and if a section falls into delay, the liquidated damages for that section become payable. Liquidated damages are normally only included in main contracts. That is because there's a risk to main contractors using liquidated damages in a subcontract, in that the level of liquidated damages set out in the subcontract may not be sufficient to cover the contractor's losses for delay. The contractor's losses for delay can vary widely because it can comprise the liquidated damages that they may incur under the main contract, but also the main contractor's own loss and expense, and potentially, depending on when in the project the works are delayed, they may also be liable for other loss and expense claims brought against them by other subcontractors. So it's very difficult for main contractors to actually pre-estimate the level of damages that they might incur if the works are delayed by a subcontractor. So generally, main contracts don't contain liquidated damages provisions. Rather, if a subcontractor causes delay, general damages kick in, and then the main contractor can recover all of its losses as long as it can prove those losses. That's not to say LDs can't be used in subcontracts. They sometimes are, but it's relatively rare. The benefit to an employer of including liquidated damages in a contract is that there's no need for the employer to prove that it has incurred any losses. Rather, the amount of liquidated damages are automatically payable, but the level of liquidated damages set out in the contract must represent a genuine pre-estimate of the loss. There was a lot of historic case law covering what was a genuine pre-estimate of loss and whether LDs might constitute penalty clauses. But the more recent approach by the courts has been somewhat more relaxed, so that now the position is that as long as an employer can prove the level of liquidated damages is not extravagant or unconscionable, the liquidated damages will be recoverable. It's also worth noting, just as a last point on this initial slide, that liquidated damages are only recoverable up to the point of completion or termination if a contractor's employment is terminated before the works are completed. So if a contractor is in delay and the employer terminates the contractor's employment, the right to claim LD stops at that point of termination, but the employer can still claim general damages relating to any ongoing delay after that termination. So moving on then to notice requirements, the JCT sets out strict notice requirements which must be adhered to by the employer before liquidated damages can be deducted. So I've set out on this slide and the next slide the contractual provisions, and then I will then talk you through what this means. So on this slide, this clause 229.1 deals with notices 1 and 2, which will make sense shortly. And this second slide deals with notice 3. So to summarise the contractual position, there are 4 notices which must be issued by an employer before liquidated damages can be deducted. So the first notice is the notice of non-completion. So this might be issued for the whole of the works or per section if sections apply. The second notice is the warning notice. Again, this can be issued either for the whole of the works or per section if you've got sections. This warning notice essentially needs to state that the employer may deduct liquidated damages. The third notice is then referred to often as the deduction notice. Again, it can either be issued for the whole of the works, or if you've got sections, it needs to be issued per section. This deduction notice needs to state that the employer will deduct liquidated damages, or that the employer requires the contractor to pay liquidated damages back to it if there's nothing that they can deduct against. The fourth and final notice is then the pay less notice. So I know we've already covered pay less notices in previous sessions, but this is where liquidated damages are actually shown as a deduction against the contractor's account. So what can a contractor do if liquidated damages are deducted? Unfortunately, there is no easy relief. If there's an entitlement to an extension of time which would reduce or eradicate the liquidated damages, then the contractor should apply for this straight away if they've not already done so. If there's a dispute over that entitlement, it might be necessary to refer the dispute to adjudication. But unfortunately, there's no quick or easy fix if liquidated damages have been deducted. So that's it from me for the moment. I'm now going to pass you back to Hannah.
Thank you. So the first clause I'm going to look at relates to defects. Firstly, what is a defect? Well, the term itself isn't defined in the JCT suite, but you do occasionally see it defined in amendments. But generally, a defect in a construction contract refers to work or materials that fail to meet the specifications or standards required by the contract. So this can arise due to faults in the work, materials or design, or deficiencies in the quality of the work itself. So JCT has a few clauses dealing with defects. The first is clause 235, which covers the position relating to defects, shrinkages, or other faults in the works that appear within the rectification period. So as I'm sure you know, the rectification period is usually the 12-month period following PC. So this clause 235 allows the employer to issue a schedule of defects not later than 14 days after expiry of the rectification period, but also any time up to that, and the schedule to issue instructions requiring the making good of a defect. So within a reasonable time of receipt of that schedule or an instruction, the contractor is required to make good the defect at no cost to the employer. Alternatively, the employer can otherwise instruct, which means he can make an appropriate deduction from the contract sum for the defects that haven't been made good. So employers will often change the reasonable period for making good defects to a set period instead. And quite often this is dictated by the seriousness of the defect itself. So for example, the employer may have different categories of defects. The most serious need to be attended to in 24 hours, with minor defects allowing the contractor 7 days to carry out necessary remedial works. Once the defects have been remedied, the employer is to issue a making good certificate. This is one of the steps that then triggers the final payment process. So defects are usually categorized as either patent or latent. Now, patent defects can be observed or capable of being discovered during the works or within the defect's liability period. Quite often, although there is nothing in the JCT to allow this, but it is the industry norm, minor patent defects are set out in a snagging list, which the contractor agrees to make good after PC. If he doesn't, then the employer can otherwise instruct and make a deduction from the contract sum for the works necessary to deal with those snagging items. So latent defects, on the other hand, are concealed flaws that may not become apparent until years after completion of the works. The contractor remains liable for latent defects even after the certificate of making good is issued, and for how long really depends on how the contract was signed. The general rule is that it's 6 years for a contract and 12 years for a deed for breaches, but there are other considerations to this, which I'm not going to go on to now. But the key point of this is to know that just because a certificate of making good is issued doesn't mean the contractor is off the hook for defects that may come to light after the rectification period has expired. So linked to defects is another common amendment we see, which is to specify exactly when practical completion occurs. I'm just veering away from defects ever so slightly here. So unamended, clause 227 simply says that when PC is achieved, then a PC statement should be issued. Quite often there'll be a new definition of practical completion added into the amendments, which will provide that PC is when the contractor has completed the works in accordance with the contract, and these are free from apparent defects, subject only to minor defects which do not affect or impair the use or enjoyment of the works by the employer. So this covers off the snagging list that I spoke about just now. Just while we're on the topic of PC, you may find other requirements that have to be met before PC can be issued, such as the giving of subby warranties, testing certificates, O&M manuals, as-built drawings. Contractors need to be aware of these sort of clauses because they can prevent PC certificates from being issued, even if the works have been completed, which could leave the contractor open to liquidated damages, as Carolyn's just talked about. I just want to raise it now, so it's something that came up recently with a client, but I'll go back to defects now. So we've looked at the position regarding defects at the end of the project, but what about during the course of the works? So there's another section in JCT that deals with this, and that's clauses 312, 313 and 314. So for any works that are not in accordance with the contract, the employer can issue instructions to remove such work, materials or goods from the site. Now, the employer can also consult with the contractor and issue change instructions to deal with such works, and or issue instructions to open up the works under clause 312 to inspect or test the works. Now, if this shows the work was in accordance with the contract, the contractor will be entitled to additional time and money for these tests to have taken place. So that's the JCT position, but perhaps unsurprisingly, clause 313 is often changed, allowing the employer to issue any instructions he likes regarding work not in accordance with the contract without the need to first consult with the contractor. Employers obviously don't like giving time and money away, so it's likely that a contractor won't be entitled to an EOT or loss and expense, even if the testing shows that the works were correct, usually if the employer had reasonable grounds to believe otherwise. So for workmanship not in accordance with the contract, i.e. work not being carried out in a proper and workmanlike manner, the employer can issue instructions to the contractor to sort it out, but the contractor is not entitled to any additional time or money in doing so. So lastly is clause 312, which is related to 313, and this goes back to the opening up for an inspection or to carry out any tests. So the standard position is that the cost of any opening up or testing, and then the subsequent making good if necessary, is added to the contract sum unless otherwise stated in the ERs or CPs, unless the inspection or test shows that the materials, goods or work are not in accordance with the contract. So one final point on defects is that the failure by the contractor to remove any work, materials or goods that aren't in accordance with the contract, or refuse or neglect to comply with a notice or instruction in this regard, is a ground for termination by the employer, which I'll come on to next. So this is really important because if a contractor's not remedying a defect, it gives the employer the right to terminate the contractor's employment. So the last set of key clauses I'm going to look at are suspension and termination clauses. So starting off with suspension. So a contractor can suspend for non-payment, but only if this relates to the employer's failure to pay a sum payable in accordance with 4.9 of the contract. So what this means is if the contractor applies for £500,000, the EA gives a certificate for 100,000 and the employer pays the 100,000 that's certified, the contractor is not entitled to suspend just because it believes it's entitled to another 400,000. This is because the sum payable under clause 4.9 is the sum certified of 100k, which the employer has paid, so is not in breach. Now, where this does apply is where either no payment notices or pay less notices have been issued in relation to an application and payment is not made by the final date for payment, or where a sum is certified by the EA but not paid by the employer. Suspension is a really useful tool for contractors, as employers quite obviously don't like the works being stopped for any length of time. But we have to make sure that there is a breach under clause 4.9 first. Also, be careful if you are suspending, and ensure 7 clear days pass after the initial notice of intention to suspend before actually suspending. Any suspension of the works before this 7-day period has passed is likely to result in the contractor being in breach rather than the employer for non-payment. So if you're issuing your 7-day notice, you've still got to carry out those works for the 7 days until that clear 7 days have passed to then issue your suspension notice. So if the contractor does suspend, and then after that period of suspension, the employer pays, the contractor goes back to site, he's entitled to an EOT and the losses flowing from that suspension. So moving on to termination, firstly, termination by the employer. So clause 8.4 sets out the grounds under which the employer can seek to terminate the contractor's employment under the contract. Now, I've added these on the slide, but just running through, they are wholly or substantially suspending the works without reasonable cause, failing to proceed regularly and diligently with the performance of its obligations under the contract, refuses or neglects to comply with a notice or instruction to remove any work materials or goods not in accordance with the contract, and by such refusal the works are materially affected. So that's the clause dealing with the failure to remedy defects that I just spoke about. Subcontracting without consent, assigning without consent, failure to comply with CDM regs and building regs. So just a point to note, in previous versions of the JCT contracts, the employer had a right to terminate if the contractor failed to comply with CDM regs. In the 2024 suite, this has been extended, should cover CDM regs, but also Part 2A of the building regulations as well. So these grounds for suspension are known as the specified defaults in the JCT suite. Now, there is another ground for termination by the employer, which is the insolvency of the contractor, and this is dealt with by clause 8.5 of the JCT D&B. Now, the definition of when a contractor becomes insolvent is set out in clause 8.1 of the contract, and the key thing here is that the contractor must have entered into one of these insolvency events before the employer can terminate. Now, this is really key. An employer cannot terminate for insolvency just because the market is rife with rumours that the contractor is going to go bust. So if the employer does this and the contractor hasn't yet entered into any insolvency action, then the employer is likely to be in breach and there will be a wrongful termination. Now, what this will mean is that the contractor, or rather the liquidators or administrators of the contractor, because let's face it, the rumours are often true, will go after the employer for damages because of this wrongful termination. Employers don't want this to happen, so it's vital you check the legal position of the contractor before terminating for insolvency. So you've got a specified default. What can the employer do? So step 1 is to send a notice to the contractor specifying what the default is, or defaults, there might be more than one. So if the contractor then doesn't remedy the default or defaults within 14 days, the employer can take step 2, which is to serve a second notice terminating the contractor's employment under the contract. So the employer has 21 days from the end of this 14-day period to serve the termination notice. If the employer doesn't terminate in this 21-day period, but the contractor repeats a specified default, then the employer can terminate anyway within a reasonable time after such repetition. The position is slightly different for contractor insolvency. If the contractor becomes insolvent, and that falls within the definition of 8.1, then clause 8.5.1 allows the employer to terminate at any time just by giving notice to the contractor. So there's no 14-day period there. That's an immediate termination on insolvency, but you have to serve the notice first. So if the employer does terminate the contractor's employment under the contract, what happens next is dictated by clause 8.7. So this says that the employer can employ and pay others to complete the works and can use all temporary buildings, plant, tools, equipment and site materials for that purpose. Now, as for the contractor, after termination, he is required to provide all design documents and assign, if requested to do so, the benefit of any agreements entered into for the materials or goods and execution of the works, so subcontracts and supplier agreements, so assign over from the contractor to the employer. Also, if the employer asks the contractor to do so, he must then remove all temporary buildings, plant, tools and equipment. So at the point of termination, the contractor isn't entitled to any further payment unless the sum had already become due at that point. And then once the works as a whole have been completed with the new contractor and all defects made good, the employer is to notify the contractor that the works are now complete, and the due date for the termination payment, which I'll come on to shortly, is 2 months after the date that completion is notified by the employer to the contractor. Now, the termination payment is calculated in accordance with clause 876 and takes into account the employer's losses because of the termination, and this will nearly always result in a payment from the contractor to the employer. Now, just quickly, clause 8.8 gives the employer the decision not to complete the works after termination. Now, if this happens, or if the works are not started by an alternative contractor within 6 months, then the termination payment process is started, with the due date for the termination payment being 2 months after the last day of that 6-month period. Clause 8.8.3 then deals with what needs to be included in the termination payment. I mean, in reality, works do tend to continue with a new contractor, but that clause is there just to make sure that 6 months doesn't pass with nothing happening. So that's termination by the employer, but what about termination by the contractor? So in an unamended JCT, there are 3 grounds for termination by the contractor. The first being non-payment of a sum due under clause 4.9. The second is a failure to comply with the assignment clause. And the third is the employer's failure to comply with CDM regs. Now, in practice, all of these specified default clauses probably would have been amended in the contract. So if you're a contractor looking to terminate, you're going to need to check these amendments first. So for example, non-payment needs to be actual non-payment and the final date for payment has passed. The final date for payment is usually increased to 21 days from the due date, so check there has been a specified default first. Similarly, with assignment, clause 7.1 as drafted by the JCT says that neither party can assign the contract without the consent of either party. However, in reality, this is nearly always amended to allow for the employer to assign, sometimes more than once, without the contractor's consent. So this default has significantly been watered down. And if the employer does assign, it's likely that that won't be a specified default, leading to a ground for termination. As with termination by the employer, there is also an entitlement for the contractor to terminate if the employer becomes insolvent. It's the same definition of insolvency at clause 8.1. And again, the employer needs to actually become insolvent. If it's just rumours, that is not enough. And if the contractor terminates off the back of a rumour before the employer has entered into insolvency, then it's going to be the contractor that's in breach. So on the giving of the notices, the periods are the same. A specified default notice first, and then if the default is not remedied within 14 days, the contractor can serve a notice of termination on the employer. Again, with insolvency, however, this just takes place upon service of the notice. So the consequences of termination by the employer are slightly different to the consequences if it's terminated by the contractor, and the consequences of termination by the contractor are set out at clause 8.12. So immediately, no further sums are due other than in accordance with clause 8.12. So this is a really important clause to work out where you go if a contractor has terminated. So the contractor is firstly required to remove or procure the removal from site of all temporary buildings, plant, tools, etc. He's supposed to do this with all reasonable dispatch, whatever that means. The contractor also needs to provide all as-built drawings so far as these have been prepared. Then no later than 2 months after termination, the contractor needs to send all documents to the employer to allow the employer to prepare the termination account. The employer then has 3 months to prepare this account and send it to the contractor. And the due date for payment of the sum in that account is the last date for the issue of the account itself. So maximum 5 months after termination. So the termination account itself needs to set out the value of the work properly executed, all loss and expense, so that the contractor's incurred throughout the works it's carried out, the cost of removal by the contractor of temporary buildings, etc., and also any direct loss or damage suffered by the contractor because of the termination. Just a word of warning, this last one is often removed as an amendment so that the employer does not have exposure to such losses. So even if the contractor terminates for employer's breach, employers tend to remove this so that the contractor is not entitled to loss and damage. So, for example, lost profit on the remainder of the works. So before the 2024 version of JCT was released, there was some confusion about the payment dates and when notices were required in relation to payments post-termination. This led to quite a lot of disputes and some parties adopting a position that the scheme falls into place because there's nothing in the contract about when notices need to be issued, what the final date for payment is. And if that is the case, as you'll know from session 2, there's a very small time frame for the paying party on a termination account to serve the relevant notices to avoid a smash and grab adjudication. JCT sought to tackle this head on in the 2024 version by including this new clause regarding the termination payment itself. Unsurprisingly, it's quite often amended, so the time periods are usually extended. Final date for payment extended, but it is a useful clause to know what happens after termination. So just a word of warning, beware how you terminate. So when serving the contractual notices to terminate, it is really important that the contract is followed correctly. Otherwise, there is a risk the termination will be wrongful, which is arguably a breach in itself and could entitle the other party to be awarded damages. So you need to firstly check how termination notices need to be issued. JCT provides that the termination notices, and by that I mean the specified default notice and the actual termination notices, need to be served in accordance with clause 174. Now 174 has been updated in the 2024 version and does allow for notices to be served by email, but only if this option is stated to apply in the contract particulars. So the contracts that I've seen, I don't know if you're the same, this option is not often adopted, meaning that termination notices still must be sent by hand or signed for or special delivery post. They can't be sent by email. So you need to check that in the contract first. Beware also that if you do issue a specified default notice, it is not deemed to have been received until the second business day after posting. You therefore need to take this into account when calculating the 14-day period of the specified default continuing to occur before you do terminate. You don't want to terminate early, as this will arguably be treated as a wrongful termination, which means you will be in breach, not the other party, and you will have to pay the losses that flow from your breach. So if you take anything away from this session today, then it should be this: check your termination provisions carefully before you terminate and ensure you comply with them. And if you are in doubt, come and talk to us. Still on termination, clause 8.3 is really important for both parties as it makes clear that the employer's rights under clauses 8.4 to 8.7 and the contractor's rights under clauses 8.9 and 8.10, so that either party's rights to terminate, are without prejudice to any other rights and remedies that either party may have, i.e. those parties' rights at common law. So common law rights that are outside of the contract. So for example, there may be occasions where there is a repudiatory breach of the contract by the contractor that is not within the specified grounds for termination, but which the employer wishes to treat as bringing the contractor's employment under the contract to an end. So the most common example we see of this is abandonment of the works. So where the contractor just doesn't turn up to site to carry out the works, this may entitle the employer to terminate using its common law rights rather than the process set out in clause 8.4. Now, the advantage to this is that you don't have to wait your 14 days for the specified default to see if they improve it. If in this example, the contractor has abandoned, the employer can immediately terminate using their common law rights for abandonment. So I've talked about some of the common amendments to these clauses already, but on the slide are some of the likely amendments that you might see on which contractors in particular need to be aware of. So we've seen the removal of non-payment by the employer as a ground for termination. This has a huge impact on the contractor if payments aren't made, but the contractor can't get out of the contract and has to carry on with the works. So whilst the contractor may still suspend, if the contractor wants out completely, he won't be able to rely on non-payment as a specified default. So be aware of this. I'll come on to termination at will clauses, but these are often added in as an amendment too. As for notices, sometimes it will be expressly state who needs to be sent termination notices, where they need to be sent, what the method of service is. Again, if you've got these amendments in, check they are complied with and get evidence. So if it says you have to send them special delivery, get your Royal Mail receipt, track it, see when it was delivered, keep a copy of all of that. As for consequence of termination, quite often the contractor's losses will be limited, even if there is a termination because of a breach by the employer. So again, check to see what you're signing up to, check if you're reducing your rights as a contractor, if you're terminating because the employer's in breach.
Okay, so we've been discussing common amendments to the key clauses, and we've been running through them in this session, but we thought we'd finish up with an overview of why standard JCT forms are often amended and what the amendments seek to achieve. So why are contracts so often heavily amended? It's not just us lawyers trying to make things more complicated, I promise. Amendments typically reflect the market's position on at any given time in relation to high risk items in a contract. So more often than not, disputes relate to these high risk areas such as design responsibility, delays, payments, and parties want to best protect themselves in relation to those areas before entering into the contract. In addition to that, the ever-evolving common law system means that there's often a need to amend certain clauses to clarify or distinguish from certain points of the common law.
So with these reasons in mind, we've listed on the slide the clauses that are typically amended or indeed added in with the intention of generally passing risk onto the contractor. Now, we've already covered off many of these either earlier in this session or in earlier sessions. So we're just going to touch upon the last few clauses here, which relate to third-party agreements, ground and site conditions, and termination at will. But first, we're just going to have a quick look at the order of precedence clause. So in an unamended JCT design and build contract, clause 1.3 says that the agreement and the conditions are to be read as a whole. The clause goes on to say that nothing contained in any contract document or any framework agreement, irrespective of their terms, shall override the agreement or the conditions. However, this is often amended to expressly refer to the schedule of amendments, making clear that nothing in the contract documents or any framework agreement shall override the schedule of amendments, as well as the agreement or the conditions. And you'll nearly always find a new article which will state the form of contract. It will say that the form of contract is the JCT D&B as amended. The article will go on to say that the amendments are deemed to form part of the JCT. And if there's any conflict between what's in the JCT and what's in the schedule of amendments, then the amendments will prevail. So if you've got conflicting clauses, which is more common than you'd think, it is important to look at what document takes precedence to work out how you deal with these clauses. Now, just a final point on this, and that's about contractors' clarifications. Now, we see this a lot, that the contractor provides a list of clarifications or assumptions at tender stage. However, these need to be expressly referred to in the contract to have any effects. And if there's anything in that list that needs to override what is in, for example, the employer's requirements, then this needs to be expressly dealt with and referred to, ideally in the schedule of amendments, if possible. Now, we see a lot of arguments where a contractor's price is based on assumptions, but those assumptions do not actually form part of the contracts. They put them in at tender stage and then it just doesn't come through to the contract. So if you're a contractor and you want to rely on a set of clarifications or assumptions, whatever you want to call them, it's really important these are dealt with in the contract and that they're given the correct weighting so they don't rank behind another document which would override what the contractor assumed at tender stage.
Okay, so moving on to site conditions. As a preliminary point, we find that contractors are often sometimes surprised to discover that under common law, contractors actually take on the risk of site conditions. And this is also the case under an unamended JCT. Conversely, the risk of existing structures is ordinarily taken on by the employer. We often see, I would say in at least 90% of the schedule of amendments that we review, we often see amendments to the JCT suite of contracts to cement all site conditions as a contractor risk. And the reason for this is often to ensure that there are no arguments concerning discrepancies between or errors within existing site surveys, which might push the standard site conditions risk back onto the employer, and also to push anything that would otherwise have been an employer risk, such as existing structures, onto the contractor. I've just put on this screen an example of the type of clauses that we regularly see inserted into JCT contracts. We tend to advise contractors that they need to consider the risks for any given site before agreeing to a clause of this nature. And that often requires certain site investigations to be carried out before the parties actually can enter into a full contract. Sometimes it's possible to negotiate a position whereby the contractor is only responsible for reasonably foreseeable risks. But either way, it's important to note that if an amendment similar to the second paragraph on this slide is included, the contractor will need to commission all of its own surveys and reports, because the contractor has no right to rely on any existing surveys or reports. Moving on then to third-party agreements. This is a bit of a personal bugbear of mine, because I see this amendment, again, in 90% of contracts. And actually, when you push back on common amendments of third-party agreements, the employers will always fold. So it's an amendment that kind of is sneakily incorporated, but employers know it shouldn't really be in there. So it's common for there to be various third-party agreements relating to projects, such as those shown on this slide. And ordinarily, it will be imperative for employers that the contractor abides by such agreements, and that the contractor does not put the employer in breach of any of these agreements. So this is fine in principle, provided that the contractor has had sight of these agreements prior to the date of the contract, and the contractor knows what it has to do, and it's priced and programmed accordingly for this. But we frequently see amendments to the JCT contracts whereby contractors are expected to comply with third-party agreements whenever those agreements are provided, and compliance with such agreements will not be a change. So there's an example of this type of clause on this slide, but it's also worth saying sometimes these types of clauses are included in a slightly sneakier amendment, whereby the amendment is actually included in the definition of a third-party agreement. So always look at the definition and the subsequent clauses relating to third-party agreements. So as I said, it's not acceptable for a contractor to be responsible for complying with documents that they have not seen. So if a contractor is provided with a new agreement partway through the works, compliance with that agreement may mean, obviously, that contractor has to do additional or substituted works. So this must be expressly acknowledged within the contract as giving rise to a change. This will then enable the contractor to claim extension of time, loss and expense, and an addition to the contract sum if needed.
I'm conscious of time, so I'm just going to whiz through this. So we've already touched upon the right to terminate at will, but it is a common amendment that we see in building contracts. So you won't find it in the JCT versions, as there's no automatic right for either party to terminate just because they've decided they no longer want to be bound by the terms of the contract. But where we see it is where an employer wants the right to terminate the contractor's employment for any reason, even if the contractor is not in breach. So this is obviously a risky clause for the contractor to agree to. A contractor will likely have planned its business around a particular project, and if the employer has a right to terminate for no reason at all, this could leave the contractor in a really difficult position, particularly if there's no right for the contractor to terminate at will in his subcontracts downstream. So if there is a termination at will clause, you'll often see it paired with wording that says the contractor is not entitled to recover from the employer any profit it would have made on the remainder of the works if the employer does terminate. So again, this puts a lot of risk onto the contractor with no certainty of profit on the works. If a contractor is going to agree to this in the main contract, the right needs to be passed down into the supply chain to limit any losses the contractor may suffer from the employer just deciding they don't want to proceed with that contractor. It is really important to note, though, that if there is no clause allowing the employer to terminate at will, but the employer does so anyway, this will be a repudiatory breach of the contract on the employer's part. An employer cannot terminate at will unless there is an express right for the employer to do so. If the employer does take such action, the contractor will likely to be able to claim all losses flowing from that breach. So if you're an employer, you need to make sure this right is in your contract before taking any action to terminate, even if there's been no breach on the contractor's part. Now, if there is no express right to terminate at will, you should also look at whether the employer has a right to omit all of the works and give the works to a third party, as this really has the same effect as terminating at will. Now, Carolyn spoke about this earlier, but it's really important to remember that even if the contract allows omissions, this power on the part of the employer will be limited, and an employer can only give the works to a third party if there is express wording allowing it to do so. So as Carolyn said earlier, the intention behind this is to allow for a situation where an employer doesn't want the work to be carried out, full stop. Not just that the employer has changed its mind and wants to work with an alternative contractor. The common law aim here is to protect the contractor from losing the work that it tendered for and won. But as Carolyn said earlier, it's often amended because you can contract out of that position. So if you're a contractor and you agree to a termination at will clause, or you agree wording that allows the employer to omit the works and give them to a third party, you need to be mindful of the consequence of this and make sure you're protected downstream if the work is taken away from you. Make sure you've got equivalent clauses in your subcontracts. Now, if you're an employer, you need to make sure you have these express provisions in your contract, because if you don't and you terminate anyway, you're going to be in breach yourself, giving the contractor a right to claim damages from you. So as you can see on the wording on this slide, this is just a couple of example clauses we see. The First Amendment allows the employer to give a notice to the contractor terminating its employment by giving 14 days notice. This is a termination for any reason whatsoever. Contractor doesn't need to be in breach, employers just change their mind. You'll often find an employer insisting on a clause like this, or even the alternative wording, also on the slide, which allows the employer to terminate for any reason immediately, so not even having to give 14 days notice first. So in addition to this wording, you'll often find a provision making clear that if the employer does terminate at will for any reason, so it doesn't have to be a breach, then the contractor is not entitled to recover the profit it has lost on the remainder of the works to be carried out. So as I've said earlier, this could have a huge impact on the contractor's projections for that year. So the contractor needs to make sure it is absolutely content to agree to this wording from a commercial perspective. So sorry we've run over for a couple of minutes. We did have some questions come in. So what I'll do is we'll send those out as we usually do. And thank you everybody for joining us this morning.
Thanks everybody.